A privilege to welcome you all here to Tiller House tonight for this discussion. We at the American Society pride ourselves in being a meeting place for people interested in international law to talk about the most difficult problems in our field and to share different perspectives and try to reach some common agreement, or at least a common understanding, and find solutions. And I think there's no topic that has been more vexing for the last decade than counter-terrorism and international law. And so we're very pleased to have this great new resource in this book. My congratulations to its editors, two of whom are here tonight, and to Oxford University Press for producing it. We're eager to hear about it and to discuss its recommendations. I want to thank also, in addition to Oxford University Press, the World Justice Project, which has sponsored this research initiative over the last 3 years. And they've got representatives here, and some materials are being set up outside, so perhaps in the reception time people can take a look at that. We here at the Society have also benefited over the last couple of years from support from the Open Society Institute for convening both public and private discussions of these topics, and we're grateful for that support. So without further introduction, I'm going to turn it over to our moderator tonight, who probably needs no introduction, John Bellinger, former legal advisor at the State Department, currently partner at Arnold & Porter, and importantly, from my perspective, a member of the ASIL Executive Council. John?
Great. Thank you, Betsy. I've always loved the word vexed. I think that is one of the best words in the English language, and I agree that this is a truly vexing problem. It certainly vexed me for my 8 years in the last administration. So thank you all very much. I will give those who are sitting in the back an opportunity there, if you'd like. There are plenty of seats in the front row, so we encourage you to come forward, and I'm serious about that if you would like to. In any case, we're here for the book launch for this wonderful book that Katya is going to tell you a little bit more about, and Anna in a moment, the Counter-Terrorism, International Law and Practice. As you see, we have 2 of the 3 editors here to give us a summary of the book. And we also have 3 distinguished commentators from both sides of the Atlantic, and I'm going to introduce them all in just a moment. But before I do that, I want just to make a quick observation based on my own experience. One, and Katya and Anna will tell us a little bit more about this, but my sense is that the book was conceived and initially launched, and the World Justice Project that supported it in the summer of 2008. In other words, during the last year of the Bush administration. And then they've been hard at work for the last couple of years. It's also my sense, in reading it through, that it provides a comprehensive view of what I would call a European view of the approach to terrorism, essentially from a human rights law perspective. And in this regard, I am reminded, as I was thinking about this, of a speech that I gave here in Washington about 7 years ago. I'm trying to think if anybody was here. It was one of the first speeches I gave as the legal advisor. I gave it at the Atlantic Council. We had the first 4 years of the Bush administration. Everybody remembered that. And there was great upset about the U.S. approach to international law, and particularly with respect to terrorism. And I gave a speech that said, essentially, are we really divided between the U.S. and Europe? And I said, there was this view that the U.S. was from Mars and that Europeans were from Venus. And I used those countries, or those planets, advisedly. And I then went on to say that no, I really did not think that there was that great a divide. That we really shared basic values, that there were, we had not joined certain treaties that the Europeans wanted us to sign. We had not interpreted things in the same way in certain cases. And that a lot of it often came down to sort of different policy approaches, including even in our approach to terrorism. And I'll just sort of give you one line from that speech I gave 7 years ago. I said, the reality is not that the United States has acted lawlessly in violation of its international obligations, but rather that the United States has not adopted policies or acted in a way that some critics in Europe would like us to do. And then I went on to say, essentially, but let's talk about these things. We have not had enough dialogue. And as a couple of you know, sitting in the audience was the legal advisor for Austria, Ferdinand Trautmannsdorf, who came up to me and said, you know, are you really serious about talking more about these issues? And I said, absolutely, I'm serious. He said, well, then I want you to come to the next meeting of all of the EU legal advisors, the co-juror, and address us, and we will talk through our different approaches to terrorism. That's how I met Peter Taksøe Jensen, now the Danish ambassador, then the Danish legal advisor. And we then had a dozen meetings between the US and the European legal advisors over the next 4 years, in which we talked through all of these different issues. And I think that was an important dialogue. The reason I mention that is that looking at this book, it does seem to me that the views that are expressed in this book, and then considering how little has actually changed in the U.S. approach to countering terrorism in the last 3.5 years, and by that I mean that the law of war paradigm has continued. There are thousands of people who remain incarcerated, not only at Bagram, or not only at Guantanamo, but in Bagram. Continued use of military commissions, a reaffirmation of the policy of rendition, and then most recently an acknowledgement of the drone program, which has killed thousands of people in at least 4 different countries. And this makes me think that there really is a significant divide, at least in our policy approach, between the US and Europe. The outrage, I think we all agree, has died down, but the differences remain. So here to tell us, I guess from at least what I perceive is the sort of European point of view from many different experts are Katja Samuel and Anna Salas. You've got their bios, and I'm going to introduce our commentators in a moment. But just briefly, Katja is a barrister from the UK who most interestingly served 12 years in the Royal Navy, including in legal capacity. And Anna is a professor of public international law at Malaga University in Spain, who has served as the legal advisor for the Counter-Terrorism Task Force of the Council of Europe. So the floor is yours to tell us both about the book and about the project, and then we will have some commentary.
Wonderful. Thanks very much, John. And good afternoon, ladies and gentlemen. I'd like to add to John's welcome, each of you for finding the time in your busy schedules to join us this evening. And particularly thanks to Betsy, Veronica and the ASO team for their wonderful organisation of this event, and Oxford University Press for their financial sponsorship. I'm going to briefly outline the project. Anna's going to talk about the rule of law framework, and I'm going to come back to the concept of prevention. And although we're touching on those issues today, they're really only headline issues, and we're only scratching the surface in terms of the scope of the book, in terms of the topics that we've included in our 38 chapters. In terms of the background to the project, 3-year multinational, multidisciplinary collaborative research project, and as I've learned to say early on when in DC, politically neutral and independent, between Nottingham University, Malaga University and the Club of Madrid, who are 80 former heads of state from 56 countries committed to furthering democratic values. And in fact, May Robinson, who's both a member of the Club of Madrid and an honorary chair of the World Justice Project, has written the foreword for this book. And it is under the umbrella of the World Justice Project. And again, that's a multinational, multidisciplinary, independent initiative which looks to strengthen the rule of law worldwide, whether at the local, the national, the regional, the international level. And it was during the first multinational forum in 2008 that we proposed doing a multinational project which looks at what does the rule of law mean in the context of counter-terrorism. And not wishing to in any way divert from John in my introductory remarks, I do have to say that although Anna and I are of course European, and we do have many European contributors, we were absolutely at pains in terms of our selection of topics and authors to ensure that this is a globally relevant resource. And in doing so, we have over 40 multinational, multidisciplinary contributors who represent every major region of the world, many different perspectives, many institutional perspectives as well. And we were very concerned, even in terms of what author, we asked to ask what topic. How would this be received on the African continent? How would it be received in Latin America or Southeast Asia? Because we believe that the findings are universally timely and relevant. And our target audience is policymakers and practitioners at the governmental and intergovernmental level. And as such, we've sought to do in-depth analysis. Just to give you an idea, my conservative estimate of the expert time involved in producing the book is about 10,000 hours. So we were painstaking in the substance, the research, the referencing, and within that, all contributions seeking to address an overarching theme, which is not only what does the rule of law mean in the context of terrorism, but how may legitimate security imperatives be accommodated rather than erode the existing rule of law framework, believing that there's sufficient exceptionality built within the existing framework such that legitimate security imperatives can be met. And as such, we resist any language of balancing security against human rights, because that can be dangerous in terms of introducing exceptionality and rule of law slippage, and to use the International Commission of Justice comment in 2009 report, the normalisation of the exceptional. And we're just going to hand over to Anna, who's going to give an overview of how we define and consider the international rule of law framework to be.
Thank you very much, Katja. Thank you, first of all, to all of you for the opportunity to take part, to give me an opportunity to take part in this event today, and to have this exchange of views with all of you. And in particular, let me thank to Betsy Anderson and the American Society of International Law for the efforts in order to organize this event, and also to Oxford University Press for their patronage. Despite the provocative introduction of the chairperson today, I'll try to follow more or less the remarks I had planned to do on the rule of law, and then we'll discuss afterwards, right? So, the first thing to say, there's a universal agreement regarding the importance of the rule of law, but there is, however, no corresponding universally agreed definition of the concept of the rule of law, whether generally or in the specific context of counter-terrorism. The four universal rule of law principles generally identify are: first, a government and its officials and agents are accountable under the law. Second, the laws are clear, politicized, as well fair, and protect fundamental rights. Third, the process by which the laws are enacted, administered, and enforced is accessible, fair, and efficient. And fourth, access to justice is provided by competent, independent, and ethical adjudicators, attorneys, or representative and judicial officers who are of sufficient number and have. Okay. Okay.
We have lots of seats up here. Please come forward. That's right, Anna.
That's okay, no problem. And have adequate resources and reflect the makeup of the community these people serve. These principles apply also to counter-terrorism in general and to counter-terrorist policies and responses in particular. In the specific context of counter-terrorism, the correct starting point is believed to be the UN Global Counter-Terrorism Strategy 2006. The pivotal importance of the rule of law both underpins and is reiterated throughout its text. In particular, in Pillar 4, five key sources of legal principles are identified: international humanitarian law, human rights law, refugee asylum law, criminal law, and of course the United Nations Charter. However, these five legal sources do not operate in isolation. Instead, they are increasingly interrelated. So the important underpinning principles here are those of equality and non-discrimination. One of the most important aspects of the concept of equality and non-discrimination is the right to equality before the courts. More generally, where people are classified into different groups, a crucial determination becomes whether they are objective and reasonable criteria for these distinctions, usually by applying a two-part test, which requires that any difference in treatment must, first, pursue a legitimate aim, and second, be proportionate. The principle of non-discrimination applies equally to the situation of armed conflict, although its exact scope and meaning will need to be determined according to international humanitarian law. In addition to substantive norms, rule of law-based counter-terrorist responses are concerned with procedural aspects of the rule of law in practice, including that both formal judicial proceedings as well as non-judicial administrative processes are fair and afford appropriate levels of due process and safeguards, not least regarding the requirements of independence, impartiality, and competence. Although it may technically be lawful and legitimate to lower some of these standards for terrorism-related cases in limited circumstances, in practice, any special criminal procedures often undermine basic human rights protections, including the ordinary due process guarantees of a criminal trial, or permit excessive and disproportionate criminal sanctions and therefore should be avoided. Similarly, minimum safeguards and rights are provided for under international humanitarian law. In non-judicial administrative proceedings, there is an increasing expectation that the same or similar rights and protections will be available unless there are very good justification for not doing so. Other more general principles are of equal importance here, such as the existence of a functional legal system vis-à-vis courts, judges, prosecutors, and defense lawyers, as well as competent and disciplined police who adhere to international professional and human rights standards while simultaneously respecting local customs and culture. Second, accountability to the law, which are also related to the importance of the separation of powers between the executive, legislature, and judiciary. Third, legal certainty, such as with respect to the clear drafting of domestic counter-terrorism legislation. And fourth, avoidance of arbitrariness, not least in terms of ensuring appropriate judicial safeguards for suspected terrorists. The importance of security to both states and the United Nations system is fully recognized. This means that the value of security and its inherent imperatives may be incorporated into the international rule of law framework where this is not already the case. Particular terrorist threats or activities are so serious that they may be considered to constitute a public emergency which threatens the life of the nation. This enables the executive to respond to such security imperatives by temporarily and proportionately adjusting its legal system to provide increased security, including through the reinstatement of law and order, and to decrease the protection of non-derogable rights and freedoms for as long as the exigencies of the situation require this. Such exceptional measures should always be underpinned by principles of legality, necessity, and proportionality. The scope of the examination of rule of law principles in operation is important also. Although much of the focus has traditionally been on individuals and state actors, and increasingly including non-state actors as well, scope needs to be broadened to consider also international organizations. There is an increasing expectation that such organizations will themselves be models in terms of reflecting and adhering to such standards and principles within their own institutional responses, even where they might not technically be states parties to the relevant obligations. It is reflective of wider discourse then, and trends towards ensuring greater accountability and closing existing or potential impunity gaps at every level. Therefore, while the United Nations has a pivotal role to play in terms of overseeing compliance with the rule of law at the national and international levels, it is imperative that it both fully recognizes and reflects its own institutional responsibilities and commitments in this regard. Finally, although these bodies of principles and their related institutions and mechanisms are generally well established, nevertheless an important underlying tension remains that most of them were not developed specifically to respond to terrorism and counter-terrorism. Therefore, tensions and sometimes uncertainty exists regarding the exact manner in which particular norms should be interpreted and applied in this specific context. This is illustrated by the relatively new phenomenon of transnational terrorism, which does not fit comfortably within the legal regimes governing international or non-international armed conflicts. While it would appear that the corpus of counter-terrorism law is emerging, this is considered to be still in its relative infancy and not to be sufficiently well-defined or developed, clear or consistent, to be treated as a coherent, self-contained international anti-terrorism legal regime. Thank you very much.
I will now briefly consider the concept of prevention. Although the book considers, as I mentioned, a broad range of issues, we've based the launch around this theme for a number of principal reasons. One, because a strong preventive element lies at the heart of effective counter-terrorism. Ultimately, the aim is to prevent terrorist attacks from occurring long before an actual attack is launched, or even to prevent other terrorist activities from occurring at all, including through the development and enforcement of robust and effective systems of criminal justice. Another is that although some of the recent and diverse state and intergovernmental practices have sought to come under the undefined umbrella of prevention, which have raised many different rule of law areas of concern and constraint, not least in terms of placing the applicable rule of law framework itself under considerable strain. In turn, this is attributable at least to another factor highlighted by preventive responses, namely the absence of universally agreed definitions and parameters of key concepts, not only of terrorism itself, but even the notion of the rule of law and the notion of prevention. While areas of normative uncertainty and space for policy manoeuvring may be attractive to at least some states, it does little in terms of achieving greater rule of law coherence, certainty or compliance. And I'm just going to look at 4 examples of what we've considered. We've considered others too. The first is anti-terrorism legislation. One key element of effective prevention is the development, implementation and enforcement of effective rule of law compliant anti-terrorist legislative systems from the domestic to the regional to the international levels. Indeed, a core underpinning premise of the UN Global Counter-Terrorism Strategy, adopted by the General Assembly without vote and having universal legitimacy, is that criminal justice responses should be the norm and military approaches should be exceptional. And certainly one might argue that effective preventive measures within a criminal justice approach could largely avoid the necessity for military approaches at all. In terms of rule of law concerns, a number of issues of concern relate to the absence of a universally agreed definition of terrorism, resulting, for example, in poor harmonisation of domestic anti-terrorist legislation, which in terms may impede effective interstate cooperation. Another issue has been the poor drafting of legislation, which has offended other rule of law principles, not least that of legality, through being ambiguous, overbroad and vulnerable to politicisation. That said, despite the rightful focus and debates on the definition of terrorism, even if one is ever agreed, I wouldn't suggest it's going to be the panacea for addressing all concerns on these issues. For example, procedural concerns when suspected terrorists are not afforded appropriate levels of due process and other safeguards. Or will it overcome the issues of achieving the requisite levels of political will to more effectively implement and enforce even existing international norms? The second is administrative detention. another practice which has become more common as a preventive measure, especially since 2001. Key areas of concern and constraint range from deprivation of liberty for purposes similar to those of criminal law, namely the removal of a person believed to pose a threat to society and or to obtain information without the disciplines and safeguards of judicial process. Another is distinctions between national and non-nationals, which offend the principles of equality and non-discrimination, or many examples of the mistreatment of detainees, whether not in the context of intelligence gathering. There's also been uncertainty and disagreement regarding the exact interpretation and application of existing rules to transnational conflicts, which were not envisaged at the time of the rules drafting, as Anna's touched upon. Another principal concern obviously has been that detention risks becoming indefinite, whether this is due to the constraints imposed by the principle of non-refoulement, or whether it's due to unhelpful political rhetoric, whether it's the war against terror or now the war against Al-Qaeda, which is without temporal or geographical limits, sometimes making it difficult to discern when an armed conflict has come to an end, such that those detainees not charged with criminal offences would normally be released. A third practice relates to intelligence and evidence gathering. Clearly, both of these perform pivotal preventive functions, with intelligence services seeking to intercept and prevent future terrorist attacks through effective intelligence gathering, as well as the collection by law enforcement agencies of evidence necessary to prosecute suspected terrorists to prevent the perpetration of further terrorist activities by them, as well as to send out a strong deterrent message. There have been many areas of rule of law concern here. Some, for example, have related to the mistreatment of those being interrogated, despite the fact that any use of violence, oppression or threats to gain intelligence or admissions from suspects, we would suggest are never legally, legitimately or morally defensible, even when responding to grave security imperatives. Another source of concern relates to the blurring of traditional functions between the intelligence community and law enforcement officials, whereby the former have become involved in such activities as arresting, detaining or questioning suspects, often without adequate training or comprehension of criminal justice processes. Consequently, not only have rule of law violations resulted, for example, arbitrary arrest and mistreatment in detention, but sometimes the very evidence necessary for prosecuting suspected terrorists has become tainted and therefore inadmissible in court, undermining the very preventive benefits of criminal justice processes. And of course, I would suggest that any intelligence gathering activities in the context of extraordinary rendition is never lawful or legitimate, again regardless of the perceived severity of the threat, nor are related impunity gaps. The final practice of prevention I'm going to touch on relates to targeted killings, of course very timely following the first anniversary of the killing of Osama bin Laden. Clearly, this is the ultimate form of preventive responses, and that has a very finite end for the persons concerned. It may be permissible for governments to neutralise what may be a very real threat to the lives of their own citizens or territory, where the persons concerned are in the territory of another country that is either unwilling or unable to constrain the activities of those terrorists as a measure of absolute resort to prevent future terrorist attacks from occurring, where express or implied consent by the host state for such intervention is given. In terms of areas of rule of law concern or constraint, under a law enforcement criminal justice regime, the governing law is that of international human rights, underpinned by the growing presumption that states may not commit acts abroad that would be unlawful on their own territory. The conventional view is that any premeditated use of lethal force can never be non-arbitrary or absolutely necessary. The hidden assumption being that unless the threat to life of others is imminent, there will always be other means of frustrating the threat that have to be considered and preferred before the use of lethal force. Consequently, looking at trends and jurisprudence globally, the position would appear to be that lethal force may exceptionally be used by law enforcement officials when trying to effect an arrest, subject to the strict criterion I've just mentioned. And of course, the use of drones and the type of armaments they may use is particularly problematic in a law enforcement context, as is any premeditated killing. In situations of armed conflict, it's permissible to use lethal force against privileged or defective combatants. However, even here, lethal force should not be used unless there's military necessity to do so. And of course, there's many other different forms of preventative practices. I'm not going to go into detail, but for non-forcible sanctions, whether imposed against states, individuals, non-state actors, or the use or misuse of immigration systems as I would suggest an unintended and unwilling instrument of prevention. And I suspect I've probably given enough examples and stepping stones for further debate. Thank you.
Thank you, both Katja and Anna. That was fantastic and a terrific summary both of the project, the book, and the 10,000 hours that went into their preparation. So that's great. You did give us lots of food for thought. I'm just sort of looking at this menu of counterterrorism legislation, definition of terrorism, administrative detention, targeted killings. That's a lot to talk about. Rendition, that's a lot to talk about. We have, for instant responses, 3 experts. I'm going to start at the far end, and I think maybe I'm going to go in that order, because then, Vega, you're going to get to sort of have the European or non-European response at the end. But on my far left, Eric Rosand is an old friend who's now, having served in a variety of different jobs, senior advisor in the Department of State's Bureau of Counterterrorism, and has been dealing with counterterrorism issues for many years. And so Eric, currently in the Obama administration, I think will give us, at least to the extent he can, some of the Obama administration's current views on these issues. Dick Jackson, I've also known for many years, now Special Assistant to the Army Judge Advocate General for Law of War Matters, and is a law of war expert, having been an Army JAG for many years. And then finally, an old friend, the Norwegian ambassador, Vegard Stroman. Vegard and I met when I was, both of us were negotiating the 3rd additional protocol to the Geneva Conventions, which created the Red Crystal, and we're delighted to have him now as Norway's ambassador in Washington. So I'm going to give each of you sort of a question which you can either not answer or try to answer as we go along. So Eric, I guess in particular, we'd be interested in hearing from you what the Obama administration has been doing in terms of counterterrorism policy, particularly at the multilateral level. But here's the curveball, which you can swing at if you want, which is sort of back to my original point, is that I think, I suspect that Katja and Anna and this group expected that there was going to be a lot more change and a lot more movement towards a criminal justice, criminal law enforcement model, and a lot less use of military force, certainly not an increase in use of military force than has happened over the last 3.5 years. And as you have been dealing with the policy issues, I'd just be curious to know whether you see that divide that I've mentioned causing trouble for you. So why don't we start with that, and then we'll move down the table.
Before getting to that last question head on, I just want to sort of commend the authors of the editors of the book for an incredibly comprehensive and forward-looking set of chapters.
Eric, I'm sorry, I'm going to ask you to move a little bit closer to you. It's not as sensitive as we'd like it to be. There you go.
I just want to, again, commend the authors and the editors for this wonderful book, which seems to offer lots of useful and thoughtful recommendations for a range of counterterrorism policymakers and practitioners around the world from different regions, and touches upon a number of critical issues, which I think, regardless of which political stripe you may wear, you would recognize as being essential for dealing with the threat today. And I think that, and I'll get to John's good question at the end, but it relates to this, which is that I think a lot of the policy responses from this administration that have been sort of seen as essentially carryovers from the previous one are in a certain sphere of the counterterrorism arena. And you can talk about issues related to the use of force when it's used, the targeting issues, and there is healthy debate going on about that, and about the continuity, and about also the transatlantic discussions on those issues. But I think the area where we've seen the consensus grow and develop, whether it's across the Atlantic or it's across the Pacific or it's with other geographic regions, has to do with prevention, but not in a legal sense. It has to do in the policy sense of that the preventative response and preventing terrorism from a policy perspective, whether it's strengthening rule of law institutions in countries so that they're better equipped to deal with the threats within their own borders before they become serious ones, and reducing the number of recruits that terrorist groups can then draw upon to then commit terrorist crimes. I think in those two areas you've seen a transformation from the previous administration, but I don't think that's politically driven as opposed to sort of the threat has changed, and thus the response on that and those kinds of issues has changed. And I'm hopeful that whoever wins the election in November will continue with these kinds of approaches, because it allows us to work with partners, whether bilaterally or even when we have difference on the legal issues. We've been able to work much more closely, I think, with our European partners and our non-Western partners on a range of very practical, sensible counterterrorism projects focused not in the military, not in the intelligence world, not in the security world, but on the civilian world of strengthening criminal justice institutions, rule of law frameworks, capacity building, etc. And I think one of the and issues related to this sort of permeate through the book. I mean, I haven't obviously read the whole book, but I, just by looking at, skimming through the book and looking at some of the chapters, reading some of the chapters, you get a sense that it's these kinds of cooperation and institution building efforts, which are not part of the legal discussion of prevention, but more part of the policy discussion of prevention, I think are again, are areas where we can get a lot of common ground in the international community. And I think we've seen this consensus grow, and as a result, the partnerships have been strengthened. And what maybe 4 or 5 years ago, where you had these legal differences, the vexing issues, were the centerpiece of the counterterrorism discourse around the globe, I don't think that element has diminished, and that's why I would agree with John in that regard, but I think the other areas where there is consensus have grown. And so it's just been more sort of, it's a pocket now where these discussions are taking place. And I think they'll continue to take place, because I think the reality is that, for better or for worse, Washington may see the threat differently than other capitals and feel the sense of the need to respond differently. And so the same legal framework can be interpreted differently as a result. So fortunately, I'm no longer a practicing lawyer, so I don't have to deal with those issues. And I won't deal with those issues if they're raised in the Q&A, so beware. But the last point I would mention, and this sort of is the platform that we in the State Department have created with many of our partners around the world to allow these kinds of very practical preventative issues to be discussed and built upon, is called the Global Counterterrorism Forum, which is a group of 30 countries that came together really with two or three objectives in mind. One is to leave the differences on the definition of terrorism, leave the differences on the other legal issues surrounding terrorism aside, and find common ground, north, south, east, west, where we can work collaboratively on projects related to strengthening the rule of law, institutions and countering violent extremism. So we've seen a new platform created where we're working with the UN, we're working with other regional organizations, many of which are touched upon in the book, to strengthen, again, the preventative tools that countries have to deal with the threat. And I'm happy to answer questions about the Global Counter-Terrorism Forum going forward in the Q&A, but one of its, two of its major contributions so far, it's been around for 9 months, is it essentially gave birth to this International Center of Excellence in Countering Violent Extremism that will be launched in Abu Dhabi, and it's the first ever training center for countries and civil society on countering violent extremism. So you have all these law enforcement academies all over the world, military academies all over the world in the context of counterterrorism training, and now we have, in dealing with countering violent extremism, a seed of an effort to train practitioners and policymakers on providing them with the tools to deal with the response. And the second is at the launch of the forum in September in New York that Secretary Clinton presided over, the members of the forum were able to mobilize $100 million in capacity building funds to support the training of judges, prosecutors, parliamentarians, legislative drafters, all in the context of helping countries move away from repressive responses to dealing with the threat to more rule of law-based ones. So I'll just conclude, and we have the second plenary session of the forum in June, which again Secretary Clinton and her Turkish counterpart will preside over in Istanbul, and again additional initiatives are going to be rolled out, all in this rule of law space, or countering violent extremism space, where again there's common ground that's more easily found than I think you could have found a few years ago. And I'm not sure, I'll just conclude, I'm not sure that's because of the side of the aisle that these initiatives were coming from in Washington, but it's more, I think the climate has changed, and I think that the situation was right for these kinds of initiatives in a way that it may not have been right for a few years ago. So I'll end with that.
That's great. That's very helpful, Eric. Sort of more cooperation on these other preventive approaches multilaterally is sort of taking the focus off some of where some of these divisions were. So that's interesting. I don't think I'll be wrong in saying that Dick is going to come at this probably from more of a perspective of somebody who's been in the military as an officer for more than 3 decades and is an advisor on law of war issues. And I guess, Dick, for you, I think, correct me if I got it wrong, Katja, but this is mostly really an endorsement of the criminal law enforcement approach. And so, Dick, I guess looking at that, is that giving the right balance to, frankly, what the U.S. government has been doing over the last 12 years over 2 administrations?
Well, John, first I'd like to say I'm really representing ASIL and the Libre Society for Law of War, and I'm the chair of that interest group here. I'm not speaking in my professional capacity as a member of the current administration working for the Judge Advocate General of the Army. That's just so all the stupid things I say don't come back to haunt the Judge Advocate General. But the short answer to John's question is no. I don't think this book reflects the balance that Katja said was attempted between security and human rights, particularly in addressing all in a balanced way the policy approaches or options that are available to governments in dealing in both a preventative and actually a military way the threat from terrorism. Let me give you a couple of examples of that. Katja's introduction admits that the book is weighted towards a criminal justice response, adopting military action only in exceptional circumstances when there is no other option. And that, on the one hand, you could look at that and say that's just a reflection of the Caroline case and its and the approach of necessity that's required before you act to use force under international law and the UN Charter self-defense regime. But when you look a little harder at at the chapters of the book, the military option is completely rejected and completely denigrated. Helena Page, who I've become a very good friend with over the years, has a chapter that talks about the concept of the war on terror and says that there is no such thing, there can be no such thing. And I would beg to differ, and I think there's a very a good both policy and legal explanation for the existence of an armed conflict against Al-Qaeda, which is how this administration has characterized that conflict. That conflict was not only endorsed by the Congress of the United States with an authorization for use of military force, but it was also endorsed by the first invocation of Article 5 of the NATO Treaty by the North Atlantic Council, every nation by acclamation right after 9/11, and endorsed it in UN Security Council resolution subsequent to 9/11. So there, I think it's almost undeniable that there is an armed conflict that exists. The question is, where does it exist, and where do we invoke the duties and obligations as well as the authorities of the law of armed conflict? ASIL has hosted a number of discussions about that issue, and most of the people in those discussions have agreed with Katya's approach that she just identified of using force in places where the host nation is either willing and asks for the assistance, or is unwilling or unable, and there's an imminent threat that exists from that area. So places like Somalia or Yemen or the Fatah area of Afghanistan, it's undeniable, I think, that there's an armed conflict existing in those places. We just had an officer return from a military training mission in Yemen. What he described to me looks so much like an armed conflict. I don't think people could deny that. Although the International Law Association said there was no armed conflict in the Fatah area of Afghanistan in last summer's report, I think the facts say something different. Dick Pregent, another good friend of mine, talks about interrogations and coercion, but probably because he wrote this thing before the 2009 Military Commissions Act, he only barely touches the surface of the impact of the 2009 Military Commissions Act on the concept of admissible evidence in the military commissions, which focuses, and Mark Martins talked about this yesterday on CNN, focuses on the fact that no evidence will be submitted unless it was voluntarily obtained. That's a pure criminal justice approach to the issue of coercive interrogation, and rejects any form of coercion, as Dick Pregent acknowledged the Army Field Manual did in 2005. Two other examples, and I've got to read to you David Turn's introduction to the Classification, Administration, and Treatment of Battlefield Detainees. As will be made clear in this chapter, the approach to the legal classification, administration, and treatment of detainees captured in military counter-terrorist operations since 2001 has been inconsistent not only with U.S. constitutional and military law, but also, and more importantly, with the international law of armed conflict. I disagree with everything in that sentence, and everything that comes after it in the chapter. David doesn't recognize the U.S. constitutional underpinnings for the armed conflict itself. He doesn't recognize the application of the law of armed conflict in a way that it's been applied since the Geneva Conventions and before, even as far back as the Lieber Code from 1863, which recognized this category of lawless brigands on the battlefield, as well as partisans or guerrillas that were parts of the armed conflict. And the military commissions section is completely from a defense attorney's perspective. I think this book would have benefited from a balanced view from a number of different perspectives. And I would submit another OUP product ought to be read along with this book to get a more balanced account. And I hesitate to do that because I wrote one of the chapters, but because I don't like to toot my horn usually. But The War on Terror and the Laws of War, a military perspective from OUP, addresses all of these different perspectives in the War on Terror. And if you put the two together, I think you could get a balanced description of the policy options that are available to decision makers in counter-terrorist and preventive counter-terrorist actions.
Well, Dick, that's great. I suspect Katja and Anna are going to want to respond. Two, I suspect they're also feeling a little bit the way I felt when I would go to European capital after European capital to explain the U.S. law of war approach, in which I got sort of the same pushback that you're maybe getting here. So it takes me back to my original point about really, are we from Mars and Venus? And to answer that question, we have a sitting government official and lawyer, actually also formerly the Deputy Foreign Minister of Norway. Tell us, is there, at least at the governmental level, do you think a divide in approach on dealing with terrorism?
Well, you're going to get the kind of answer that you would suspect. It's not really a yes or no. Let me start by saying that I thought the book was very useful, but of course it wouldn't encompass absolutely every view that you have. So of course it's familiar to someone who's like me, who spent this first part of her career in the criminal justice system. And I'm listening to what my neighbor here is saying, and I'm sure there would be other aspects, but it would probably be another 1,156 pages. But you know, a volume 2 would not be a bad idea. Yeah, I think there are European views, but you know, I represent a government that is not even a member of the EU. So I should be careful, and there are so many voices. So you would find in Europe you would be able to find several things. But I suspect that there, at least you would find another emphasis on, than you would at least on some points in America. On the other hand, I think that the divide, I would agree with your sort of summing up, John, that I'm not sure the divide is that great on the rule of law issues because of vast military engagements. There would be other things that for practical reasons that you would stress. Norway doesn't have such a, I don't think we're running around in Yemen. We have a contingent in Afghanistan, and the same issues to some extent arise. But there would be. I'm sure there would be a different kind of factual background. But I think your conversations that you had when you were legal advisor and came to. But I will yield to the Danish ambassador, who's on the first row, who participated in those discussions, and I was not there. So I'd call for his intervention on these talks, but all I've heard is that they were very useful. And after you've gone through it for a while, you actually it boils down to maybe the divide is not that enormous. I mean, I'll give you a case. I was in the Security Council. I was the Norwegian deputy after we were members of the Security Council in New York after 9/11, and we wrote. We had a hand in writing the resolution. And it was late at night, and I had gone home, and I was actually in my pajamas, and I got a phone call which said, "You have to come back. You have to come back. We've got ourselves into some legal difficulty." And I said, "What's the problem? I'm tired. What's the problem?" Well, someone is insisting that we should write into this that whoever was responsible for 9/11 should receive justice, not be brought to justice. 1 o'clock in the morning. Well, I was translating into the languages that I know in my head, receive justice, brought to justice. But we live under the tyranny of the English language, so so I went back into the hall. We had 2 or 3 hours from 1 to 4 o'clock in the morning. Completely of no interest to anyone who wasn't a native English speaker. The Chinese asked for the floor and said, "This is in Chinese, it will have the same consequences." There was probably no records in the room. The Russians, and it was now Foreign Minister Lavrov who was speaking for the Russians, and he had a bit of the same. Oh, come on. I mean, apparently in English, receive justice sounded a little bit more so, a tomahawk knocking on your door or something like that. And the English speaker was making a big fuss about this. That receive justice means that something might hit you, that not you will be dragged to court. But in my language, it's no. You would use be brought to justice, which I think we ended up with, and I don't know who suggested the receive justice, but I just want to make sure that sometimes these things are a play on word, and you make a big fuss out of slightly different approaches to addressing rule of law limitations. Let me then speak for Europe a little bit and say that remember that terrorism was quite an issue in Europe long before 9/11 and a huge interest in America. I mean, we have ETA in Spain. In Spain, we had Baader-Meinhof in the 70s in Germany. It was a huge problem, was defeated and went away very efficiently. We had the British. I will certainly not speak for the Brits. They're normally able to express themselves in English about these issues, but Northern Ireland. And they will be willing to speak at length about the measures and how they balanced their security concerns and rule of law concerns in Northern Ireland. So there would be, long before these issues had been discussed, at the time when terrorism, I think in America, when I came to America first in the 70s, was not really something that was addressed here, the same thing. So a little bit sort of respect that they come out of a different tradition where some of these issues were actually being addressed. I'll come to that, if you allow me 1 or 2 moments, on the 22nd of July case that we have in Norway at the moment, which is commonly referred to as a terrorism case. The individual in question, which is prosecuted for actually something I would, as an old magistrate, describe as execution of 67 children individually, because that's what it is. The facts are absolutely horrible. And then there were 10 more people killed by a bomb. But you're really talking about systematic, one-by-one execution of 67, mostly minors. It's commonly referred to as terrorism. And terrorism, language, almost, language which you're accustomed to from, I'm not necessarily now being very precise legally, but psychologically, language that we're accustomed from war-like, the laws of war, almost like international humanitarian law. Now the prosecutors have kept their head cool, and he is prosecuted for 67 individual murders. Well, actually 77 individual murders, which I think is absolutely correct. But it's a massive case, it's a massive test for us, because there's constantly this public perception that this is an act of terrorism, because he's politically motivated. It's clear that he's politically motivated. So the system is in a way tested, but in a very strange way that we have met terrorism. Because he would like to be labeled a terrorist. He doesn't want to be labeled a mass murderer. This is a terrorism, it's politically motivated, he is at war. He's at war, he's protecting Europe against Islam, that's the thing. It's a weird sort of political motivation, but it's there. It's a different angle on terrorism. I think actually our legal system has stood up. It's hard for the victims, the survivors, the victims' families, to see a system which allows so much attention and is such a platform for someone who's committed evil acts like this. And the facts are clear. He commits to having done it, and he's more than willing to do it again. It's a very dangerous individual. But the legal system actually provides a fantastic base when his explanation, which is full of hatred and very insulting things, both towards the people that have been killed, their families and everything, is a harsh test for the limits of the rule of law. Slightly different perspective, but I wanted to share it with you, and we're going through it. It's not easy. It's not easy. It takes its toll in a way on the whole population. This is, for us, per capita, a much larger a much larger thing than 9/11. Many more people compared to the population was killed in this incident than it was in 9/11. And I was in Manhattan 9/11, which was also a terrible thing. And the impact and the sort of psychological impact on the population, I in a way recognize some of it. Finally, I'd like to just to wrap up and say that the chapter that I would go for, if I were in a way that I in a way would be, well, there are many, they're good, but I like the one on detention. I don't necessarily agree with everything in the detention chapter. And here again, I think that, and it's written by someone, an old acquaintance, Nigel Rodley, that I respect a lot as a lawyer and as a lecturer, but I wouldn't agree with anything because, anything I would, but with everything, simply because we all come out of a different tradition. We use administrative detention as part of our legal system and would like at least to have a fair hearing for that, which is sometimes hard, and I struggle in America sometimes. Because, administrative detention is part of your legal system. No, please no. Justice Ginsburg, I sat next to her for dinner on Friday night, and a forceful woman, so she leaned over and she said, I would like you to argue hard for administrative detention. I'm not sure I'm going to agree with you, but please. So I had my moment and argued hard, and of course I made the arguments that we don't have the death penalty. The maximum penalty, for instance, for this 22nd of July individual would be 21 years, but he most likely will be locked up forever by administrative detention renewed every 3 years for the rest of his life, which might sound strange to an American audience, but we actually think that is a system that is defendable, both here and in the presence of Supreme Court judges. So the detention chapter, both in the pre-trial as part of the system, what Nigel calls, again, it's the tyranny of the English language, he calls administrative internment. I thought in a way it was useful, but again, there would be other aspects. But I actually highly recommend the detention chapter. It illustrates many of the rule of law issues that it's necessary that we have an ongoing conversation about.
Figure that is fantastic. So thank you for all of those commentaries. I'm going to do the following and make one brief comment myself. I'm going to turn it over to Katja and Anna because I can't let you go to questions without you giving you a chance to respond. And then in 5 minutes, but I'll get your responses short, then we'll open the floor to discussion. The one thing I'll say, and Vega raised this, and you touched on it, it will not surprise you that bar none, the question I got asked most frequently in my discussions in Europe was sort of the one that you raised, is, the United States is not the first country to have experienced terrorism. We had the Red Army faction, the Red Brigades, the IRA, the ETA, and we managed to deal with this without all of this, overreaction, military use of force, so war on everybody. And why is it that you can't use your criminal justice system? And the difference is the following, and this is why, in fact, the dialogue was important. One, to my knowledge, every single one of those people that were arrested in Germany, Italy, Spain, or the UK, or in Ireland, were arrested, in fact, on the territory of those countries, and they were subject to the criminal laws of those countries. And in most cases, in fact, were arrested by the law enforcement officials of those countries, perhaps not always in Northern Ireland. The U.S. federal criminal law did not apply in most cases to the individuals captured in Afghanistan. This is the cleanup in legislation that was necessary after 2001. It never occurred to us that we would need to have federal criminal law that applied to foreign nationals in foreign countries who had taken no action at that point against Americans. The laws just didn't apply. Of course, yes, KSM, others, I personally have gone on the record saying I would have liked to have seen them tried in federal court. Those people had committed federal crimes. But the vast number of people who were captured by our military on the ground in Afghanistan had not committed a federal crime. So the answer is, well, maybe we should have just let them all go because they hadn't committed a federal crime. But that was one of the conundrums. That was why the European criminal justice experience with domestic terrorism did not fit neatly what we were confronting and continue to confront, I think, every day, as Dick has said, overseas. But over to you all, and then we'll open the floor.
Well, I'm happy that the chairperson turned away his opinion because I couldn't agree more and I couldn't disagree more in principle with what you said in the beginning. So I would say, yes, I do agree. We share the same values, obviously, and it's very easy and in a way, the same policies as well. Because if you have a look to, for instance, the reaction of the Council of the European Union when the secret flights were known, and the European Parliament wanted to make a report and recommendation on a resolution against that policy and those events, the Council of the European Union said, the political organ said, oh, okay, so we are not doing well, just let's organize that instead of let's prohibit that completely. So, and the Parliament said, no, we cannot go ahead with that. We cannot allow those flags occurring. And Germany was involved, and Spain is still involved because the judge hasn't made his judgment yet. So the policies and the values obviously are the same. The United Kingdom is leading now a group of states protesting continuously because of these sentences rendered by the European Court of Human Rights. Cases, for instance, A and others, the case of administrative detention, and they are saying, or even more, those concerning the extraterritorial application of the convention, saying we didn't sign the convention for that purpose. So perhaps the court is going beyond what we wanted the court to do in the convention. So policies, values are the same, obviously. But that's my agreement. My point of disagreement, I don't think the point of departure would be Europeans against the United States. I wouldn't like to put myself in the wrong corner of the ring. So I don't think that's the point. I think the point is the approach. So you can give a military response and you will have an echo, you will have a response by the others. If you use that, there will be responses, there will be criticism, obviously. If you use another approach, you will have another criticism and responses. In this book, I don't know why, normally when we think, oh, I do, because it has demonstrated this lethal reach, lethal effects. We are not talking only about fundamentalist terrorism. We're talking about the ITA, we're talking about the Chechens and Russia. Well, a lot of cases in the European Court of Human Rights talking about that. And those cases are cited also in this, are quoted also in this book. A lot of cases against Turkey. So, and against Spain, concerning matters of freedom of expression, freedom of speech, political reasoning, and so I don't think we should do this division. Just perhaps it's a bit difficult to apart from Europe to make a balance of that possibility, the judicial approach, because we have a court, the European Court of Human Rights. We have another court, the European Court of Justice, who forced the United Nations with the sanctions regime to be more protective with the Kali case, for instance. But it seems that states in general, also Europeans, don't want to have a criminal court to deal with terrorism, for instance, and the Kampala summit demonstrated that. So we do not progress in the United Nations with the Comprehensive Convention on Terrorism. So I wouldn't say that's the scenario. That's all.
Last word, Katya, and then audience. The floor will be open in a moment.
Okay. Thank you. So many wonderful issues that I could pick up. I'll just pick up on a few. One is to say, both in terms of as a project team and how I'm responding, although I am very much British born and bred, I'm not responding as best as I can with whatever inherent biases one has. As a European, I'm responding as an international lawyer who has no political agenda, and we've had the luxury of being able to step back and from a purely international law perspective look at trends and developments around the world and make some observations. Another which I think is very important, and I endorse what Anna's said, is to talk about sort of US European, I don't think it's helpful, not least since there's almost, depending whether you look at the membership of the European Union or the Council of Europe, in the context of the latter, it has almost 50 member states, and there is no one state perspective. Of course, you can have regional norms which are reflected within the outputs of an international organisation, or the European Court of Human Rights. Of course, its jurisprudence is very influential. But out of those contexts, there isn't one European position. One is to sort of picking up generally, comments, strengths and weaknesses of the book. And of course, I don't think any book can be perfect. You work within constraints. We push the limit to our 537,000 words, and you have to call an end. And you are limited to your author availability as well. So there is some reality. But I acknowledge that there's other issues that we'd hoped to include, but for practical reasons we weren't. In terms of just one or two specific observations, I'm afraid I completely disagree with Dick's observations about us rejecting and denigrating military responses. That's completely not the case. The book as a whole, in terms of the topics it takes, it is biased towards criminal justice responses, because not least within the global counter-terrorism strategy, it does state quite clearly in Pillar 4, Paragraph 5, that criminal justice responses should be the norm and military responses should be exceptional. So we don't at all reject that in certain circumstances a military approach is both justified and appropriate. But we do look from an international law perspective at what the rules and the jurisprudence say, and for its well-established jurisprudence since 1995 of the Tadic case in the ICTY, in terms of establishing what the threshold might be for crossing an armed conflict. So what we look is that has that threshold been crossed? And if the threshold of violence has been crossed, such that an armed conflict is appropriate, then of course we would endorse that. What we do resist fairly robustly is attempts to potentially create impunity gaps, and certainly some of the discourse about there being a third paradigm, a special paradigm emerging, which I would suggest was certainly an attempt by the US government. I have to say, as an aside, as a book, we look at state practices and we don't attack any government. We merely look at state practices and comment. But responding to this particular issue is an attempt to, I would suggest, have one's rule of law cake in terms of being able to have maximum manoeuvrability in policy responses, and also eat one's rule of law cake in terms of seeking to limit the potential or broaden impunity, lessen accountability gaps. And I'm afraid we would reject as a project those attempts. Also in terms, I think it's important, even if you look at Security Council Resolution 1368 and 1373, of course they endorsed the criminal justice paradigm. And indeed, you look at 1368, it both leaves open the option for a military response, but equally it affirms the criminal justice response. So we're not saying one to the detriment of the other, we're just saying in accordance with the clearly established rules that we suggest exist under international law. Another just general comment that I want to make refers to relating to the point on the discourse of war, on terror war against Al-Qaeda. It's the rhetoric that we reject, in that, the language of war was dropped in 1945 with the adoption of the UN Charter. It has all sorts of potentially unhelpful legal connotations associated with it. And of course, it's not the military responses where appropriate that we reject. It's, in a sense, it's where it brings ambiguity into existing rules, not least when does the conflict end on a particular territory that people should be, for example, released and not indefinitely held. Another issue is, and I really noticed this as the project manager and the editing and the various discourse that I had, one of my observations in terms of the relationship between the US Constitution and international law is that it raises a wider issue, which is namely the relationship between national and international law norms. And in particular, where there's any conflict, where there's any difference of approach. And whether or not there are normative differences on particular rules, what came across to me very strongly in the process of doing this project is that within the US, and of course this is a generalization, but it appears to be very strongly US Constitution first, international law second. And so much of the discourse is framed around the US Constitution. And of course, I'm not saying that's not important, that it's not pivotal, but there's a real tension there in just quite what the key role and implementation of international law is. And certainly I would come from a school of thought is that if a state subscribes to international law obligations, they should be adopted and implemented in their entirety within a national jurisdiction and enforced as such. And my just very final comment on the issue of administrative detention / internment. We recognise, of course, there may be circumstances that it's appropriate, not least when you look in an armed conflict context. Prisoners of war is a form of administrative detention. But in terms of, in a sense, the other legal, dare I say, pickles that some governments have found themselves in, is that where possible, administrative detention is best avoided in the first place.
Excellent. Well, I apologize to the audience for going over and not opening it up to the floor for a while. I think we have been provocative here. So I think we've given you about 15 minutes for questions. And I think what I will do is, if you can put your question to a particular individual, and then rather than get 5 responses, I will just try to get a single response so that we can get more questions and answers in.
Good evening. Thank you very much for your very thought-provoking comments this evening. I'm Dixon Osborne with Human Rights First. And the question I have is this. There are policymakers and commentators here in the United States that say that we are at war, that the war is global, that the war is going to go on for decades. The Powell-Weinberger doctrine says that you go to war when the objectives are clear, that there's a clear strategy, that there's a clear exit, and you have overwhelming resources to be able to apply to it. And you can see that we've already had the exit strategy in Iraq. You can see the exit strategy coming up in Afghanistan. But I don't see it if you extend this concept of war, globally and forever, to this more nebulous concept of terrorism. So the question I have is, are we at a global war that's going to last for decades? Or are we at a pivot point now where we can shift from a law of war paradigm to more of a criminal law enforcement paradigm?
Great. I'm going to let either Dick or Eric answer that, or both of you if you want to.
Thanks, you were very gracious, Eric. First of all, this is a policy question way outside my area of expertise. So I would just offer that question has been put to Congress, was put to Congress in the last National Defense Authorization Act, the question of how long the authorization for use of military force lasts, and that's a decision for the political branches, both the executive and Congress, to deal with. So I would say that authorization for force still exists, and it authorizes from a U.S. constitutional perspective, our use of force overseas for as long as that AUMF lasts. But I want to add that I'm talking about things from a military perspective because that's where I live. But I would submit that there is a very balanced approach to counterterrorism in the U.S. government. I mean, you read the paper today and you look at intelligence successes in intercepting another underwear bomber. You look at military successes in the last couple of weeks in drone strikes in ungoverned areas. You look at law enforcement successes in convictions in federal courts. In the last week, I've read of 3 separate federal convictions. So that there is a balanced approach within the United States, and we have looked at it from a human rights and domestic constitutional perspective, and I think rebalanced domestically our approach. David Ignatius just talked about this Monday in his very good op-ed piece.
Eric, do you want to add anything?
Yeah, I won't punt completely. I'll just say that I think you've hit on one of the key challenges going forward is going to be, with Al Qaeda core by almost everyone agrees is largely diminished. The threat is more diffuse than ever, and you have places like Yemen, Somalia, even North Africa being places where Al Qaeda affiliates are active. And what's going to be the applicable legal framework for us, for the U.S. and others, to go after terrorists there when they don't have the criminal justice capacities in those countries to deal with the threat. And so I think we're back at the same point that John mentioned earlier, post 9/11 in Afghanistan and Pakistan, particularly in Afghanistan, where there wasn't the infrastructure in place to deal with the threat using the traditional criminal justice response. And so what's going to be the legal framework going forward in those new areas that weren't the areas of operation, as it were, 10 years ago?
Yeah.
Can I just say one thing on that, without taking issue or really trying to belittle the fight against terrorism? I think that some of the rhetoric around war and armed conflict is, could I say, at least complicated, in the sense that it doesn't really illuminate the issue. Because war, most of the people in this hall are lawyers. I mean, the laws of war that we were taught at the beginning of law school, and then the understanding of the Geneva Convention, we started to have, what an armed conflict and it meant, and I have all the respect in the world for people that really implement it. But then came this sort of rhetoric about, war on terrorism, and war, and the other sort of more populistic word that was used was to fight against terrorism. And in a way, it narrowed the perspective and the debate a little bit, because we will, coming to your timeline here, we're probably going to be doing this for a long time. And I think we just have to accept that. And then it's a question of whether that we are, the war, or how long the armed conflict is going to go on. It's actually not going to haunt us. It's going to be something that in the end might limit you a little bit. Could I offer you one linguistic thing? In French, which is my third language, I'm not very good at it, but in French, the word you would use would be a word lutter. La lutte against terrorism. Which really doesn't have a good translation in, I have Scandinavian languages, Norwegian really doesn't have a very good translation in our language, and it's difficult to translate into English, but it means something you fight, or something that but you fight it, it can be in physical fight, if there are any native French speakers, help me out, but it can also mean something you fight philosophically, emotionally, politically, it's more of sort of a comprehensive scheme. It's something you go after, but you go after it with your whole sort of society, your whole, with many, many measures. War, in a way, narrowed the thing. This is a terrible threat, but it narrowed it in a way to only to focus on sort of the physical, which is very important of it. So I think in a way we might early on there would have been well helped if everybody had a word for la lutte.
I'll take a couple more questions and then we will break.
Thank you. Mike Asplet from Georgetown Law. My question is about the scope of the battlefield that was kind of touched on before. And it sort of seems that in the sense of targeted killings and drone strikes, the battlefield is wherever states consent it to be. I mean, you can undertake these drone strikes wherever you perceive a threat and where the consent is. I'm just interested on sort of the framework that governs that kind of allowance for states to consent to these sorts of things to come into their own territory. It seems to me it's sort of, on the one hand, you have the sovereignty of a state which has, governs over its own citizens, and Yemen can truly say, well, come in, do what you've got to do. But on the other hand, you're sort of, I guess you're eating somebody else's rule of law cake, because you're saying that Yemen doesn't have the rule of law framework in place, and therefore it entitles you to go and do this. So I'm just interested in some perspectives, or perhaps Dick, your perspective on really what the authority is that can be relied on for Yemen or other states to consent to these sorts of activities to take place.
Let's say I'm going to do one on, maybe Dick on this side, then one on this side, and then we'll take another question.
Okay, your question really is about the relationship between Article 2.4 in the UN Charter and Article 51. In the relationship between sovereignty and the use of force by states against threats. And I think it's pretty clear that in three different speeches, Jay Johnson's speech, in Attorney General Holder's speech, and in Brennan's speech, that there are, and I'm not speaking for any of those, I'm just pointing this out, there are really two answers to that question that are offered. The first is that we're in an armed conflict with Al-Qaeda. And when we were in an armed conflict with Germany, if we found the Graf Spee in the territorial waters of Argentina or Uruguay, the Brits in that case took it out. But if you're talking about a sovereign country, the second explanation really applies, and that is that the nation has a responsibility through the laws of neutrality, if it's a war, or even through its own sovereign state responsibility to prevent attacks coming from their state. So if they're unwilling or unable to prevent attacks coming from their state, then the state has the authority under the UN Charter to defend itself in that territorial state. But I think we're leaving something out, and that's state consent. And state consent is still a big factor. I mean, there are a lot of these places we're talking about. There are non-international armed conflicts going on with those states, within those states, and those states have requested assistance. I don't know which or when or where, but I would suppose, and at least there's been some newspaper reports of some aspects of state consent involved. So that's a piece that you have to also factor into account, is the state consent aspect.
Gotcha, Anna?
Just to completely agree, it is an Article 2.4, Article 51 UN Charter issue. I guess in terms of what's acceptable, it comes back to three difficult concepts where the exact overlap or crossover point isn't always clear, namely self-defense to attacks which have actually occurred, preventive to stop imminent attacks from occurring, and preemptive. And whereas the further to the left of that spectrum you are, I would suggest the less problematic it is. But the more that, for example, the use of lethal force is moving to the preemptive, that there's a distance from the threat, or also even what the paradigm is, whether it is an armed conflict paradigm at all. And if you look at a lot of the drone strikes going taking place at the moment in the Afghan-Pakistan border, to my knowledge, we're not in a situation of armed conflict with Pakistan. So one would suggest that targeted killings are therefore taking place under a law enforcement paradigm, at least on some. You have to judge each case on its facts, but look at Pakistan. So you look at, well, the issue is not so much the use of drones per se, but how they're used, who they're targeting. Is it premeditated? What arms are they using? Is it more preemptive? And of course, when one talks about a program of targeted killings, you know, the way that I defined what the jurisprudence is at the moment, certainly from the European Court of Human Rights and the Human Rights Committee, they're very strict in saying that, you know, it really is a last resort. It's, you know, if arrest is being resisted and there's no alternative means, which raises all sorts of interesting issues about some of the use of drones at the moment.
Betsy, can we do
I think one more.
one more? Very good. There is one in the far back.
I think I can do it without the microphone. I'm George Lyle. The question was more of a comment. Perhaps one of the problems that many people have had with the term war on terrorism, if it's designed to be a perpetual war, then there is no point where you can ever stop making wartime decisions. So drone strikes, incursions into other countries, when you're always in a war mindset, all of those things instantly become justified. So we never have the chance to take ourselves out of a war mindset.
Well, I would just suggest we're not in a war mindset. We're in we're considering a range of options to deal with a threat, a terrorist threat. And it's a real threat, and it's an extant threat, and I think it's evident that the U.S. government is using a wide range of means of dealing with this threat.
Okay, I'm not going to ask for wrap-up comments from everybody, but if anybody was dying to make a final comment, then I will give them the chance to do so. No? Then in that case, I want to thank our presenters. Extraordinary effort put together all of these papers. Thank you very much. Thank you for coming to Washington to explain it to us all. And to our discussants, thank you for your provocative comments. And we welcome everyone to the reception.
Right.